Bring him back here. You're in contempt. That's 30 days. You got anything else to say? Anything else you want to tell me?
You guys, you just like.
Anything else you want to tell me?
Yes, I do.
What? You better watch your mouth because you're going to get another 30. You're going to get another 30. What else do you want to tell me?
A defendant disrespects the judge, bangs on the podium, and shakes her head. Another defendant gets hit with contempt and 30 days. The judge's message? You better watch your mouth because you're going to get another 30.
Okay, what are we doing?
I invite my client to refuse to change the answers. I tend to agree with the breakdown.
So what, you're willing to withdraw? Sir?
Sir.
What do you say?
I'm not his client, sir. He's not, he's an ineffective assistance counsel. He's not representing to his fullest potential. That's what I believe, sir. Sorry if I was speaking out of turn.
Oh,
Apologize for that.
so who do you want to represent you?
Anybody but this guy.
Anybody but this guy? Why?
Yeah, because I mean, sir, I mean, can I speak?
Sure.
I've been through the system a few times. I mean, I'm a lawyer. Obviously, I'm not a lawyer. I really don't know a lot, but I think that I've been represented enough times to know that somebody should represent me better than this guy. And when I come in and speaking to this guy, and he's talking to me like he's a prosecutor and he's supposed to be my lawyer, then yeah, we got a conflict of interest here. So I would really like to remove this guy from even helping me at all. I don't even want to speak to this guy whatsoever.
So he's speaking to you like he was a
Like
prosecutor?
I'm just like no, he's speaking to me like I'm like yeah, like he's trying to fry me just like the prosecutor was trying to fry me. So I don't got no type of talking to this guy at all. I don't even want to speak to this guy. Not even at all. I don't got nothing to say to him. And I try to explain myself, and he's like, it was just yeah, it's not gonna work for me. It's not gonna work at all.
Oh,
And that's the best way I can describe it, sir.
that's pretty descriptive.
All right. All right. I appreciate it. Let me
You do realize that sometimes defense attorneys do that?
I do, but like I said, sir.
Well, hold on.
I mean, like I said, I'm not a
Sometimes
lawyer.
defense attorneys do that to challenge their client.
I don't want to defend
But
somebody
not-
challenge me. I want somebody that's work with me, not challenge me.
Well, sometimes defense attorneys have to challenge you
All right, well.
because sometimes there are hard questions to answer, and he wants to prepare you as to how to answer. But you don't like that exercise because you want somebody that's just going to patsy you and just tell you everything's going to be okay.
Absolutely.
Okay, well, I don't know that they have those in that office.
I'm not looking for that. I'm not looking for that either.
So,
I'm just looking for somebody other than this guy.
so did you, somebody other than this
Somebody
guy?
other than this guy. Yeah, that's it.
Yeah, he's one of the best attorneys out there, but that's okay. You don't want him. That's fine. That's your business. That's your business. It's not anybody's business. That's your business. So I don't know how to do this because he's just part of an office. So there's no withdrawal. Did you talk to anybody at the public defender's office about your concerns?
And this guy came to see me one time. I told him, man, you know what I'm saying? Pretty much I didn't want him to be my lawyer, and they sent me in. So, I mean, I don't know what I'm supposed to do about it, sir, to be honest with you. Maybe you can help me out.
Help you out how?
Any way you can, besides having this guy represented.
Well, I don't run that office.
Okay, sir. I guess I have to go through the proper procedure then.
What a concept.
Yeah.
How long is that going to take you?
I don't know. I mean, every day is, every day I can kind of be in jail, so I guess it don't matter.
Oh, doesn't matter.
I mean, it does.
So I can put it out to wherever I want?
What's that? No.
Never mind. Okay, well,
Let's not do that now.
well,
Yeah.
see, that's what happens when you represent yourself.
I ain't trying to represent myself. I ain't touch mine.
Well, yeah, I can tell. I really can tell because if you're trying to fire this guy, yeah, you got a problem. Mr. Mellinger?
Your Honor, I believe you might be able to get somebody assigned to him within a
So you want a week out?
I would.
That's amazing. After the horrible things he tries to say about you that nobody else believes, just be quiet. That nobody believes, you're still advocating for him in terms of getting the shortest time. I got to give you credit, counsel. Because I would have asked for a date sometime in August. But I'm that vengeful. We'll adjourn it out 1 week and see if they can get somebody represented maybe to his satisfaction, maybe not.
Much appreciated.
So I'll adjourn this out May 9th, 2024. (9 a.m.) And if they do reassign, and sir, so that you understand, they don't have to reassign. That office is there. You haven't really stated to me a conflict other than that you don't like the person. So that's not a conflict. Huh?
I don't know, nothing like it. I just feel like he's not representing me like,
I know. With your law degree, you made that decision. All right. Thank you. Bond will continue. Courthouse case, people versus Vincent Lambert. Your name, sir?
Vincent Lambert.
Thank you.
This time, there's no offer for my client, so we request to waive and seek an offer of service.
He's waiving his right to preliminary examination.
That's correct.
Is that right, sir? So you're waiving your right to a preliminary examination?
I guess so.
Well,
Yes, Your Honor.
you know what you're doing, sir?
Yes, I do. I don't know why my answer got me so direct, but yes, I am.
Why what? Why what has to be so direct?
Why my answers have to be so direct, but yes, I am waiving my right for a preliminary.
You know what? You better check your attitude with me.
Answering your question, sir.
You can go back. I'll see him in a minute. Mr. Belvisi, check your client. Because not to. Oh, wow. Okay, bring it back here. You're in contempt. That's 30 days. You got anything else to say? Anything else you want to tell me?
You guys are just like.
Anything else you want to tell me?
Yes, I do.
What? You better watch your mouth because you're going to get another 30. You're going to get another 30. What else do you want to tell me?
Nothing at this time, Your Honor. I apologize.
Thank you. You are on your way out. We'll bring him back later, maybe. Hold those. Court, that's called the case people versus Thomas Styron. Your name, sir?
My name's Thomas Styron.
All right. Mr. Styron, you still wish to represent yourself? All right, I do have to advise you that you are before the court on 2 felony charges. You understand that, as well as 1 misdemeanor charge. You understand that, sir?
There's 3 charges I'm facing?
Yes, sir.
Yeah, I understand I'm facing 3 charges.
Okay. You understand that one of those charges is fleeing and eluding 3rd degree? And that's a felony punishable by up to 5 years incarceration?
Yeah.
Did you not understand that before, sir?
I've got 3 different sets of charges. My charges have changed 3 different times. Since I guess this.
Are you,
Sorry.
what do you mean? Go ahead.
So, first I was told it was obstruction of police investigation or something like that, and driving with no operator's license or something. And fleeing and eluding to in the first, now I get it's the third, is what you said?
Yeah, Mr. Styron,
Sir.
it concerns me a bit that you say that because I'm looking at it and it looks like the charges have been consistent throughout. So I'm going to ask you this. Do you want to be represented by an attorney to help you out, or at least sort that out?
I'm okay with that myself.
Well, are you really? Because when you come before me today and I tell you what you're charged with, you're telling me, and this case has been going on a bit, you didn't tell me. I do now understand.
When I
Hold on a second. I'm not trying to do it to punish you. I mean, if you want to represent yourself, you can represent yourself. I'm just saying that there's great danger in doing that, particularly if you're not sure what those charges are, because you're facing felonies.
I understand. I'm willing to assume the risk of represent myself, yeah.
It's your life. The fleeing and eluding third degree is a felony. Sir, is punishable by up to 5 years incarceration and or $1,000 fine plus court costs and mandatory suspension of your driver's license. You understand that, sir?
I do.
Count 2. Charge of attempted resisting and obstructing a police officer. Well, not attempted, but the actual assaulting, resisting and obstructing a police officer. You understand that charge, sir?
I do.
That is a felony. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that? Third charge is that of operating while driver's license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
I got a question saying that I don't have a driver's license, so I don't understand how I'm facing that charge.
Sir, I'm not here to answer the question. I mean, that's one of the reasons. Understand something. That is one of the reasons why you would get an attorney, to be able to give you those kinds of advice so that you know what you're facing. That in and of itself is a great peril if you don't know why you're facing a charge and want an answer to that. But right now you can't get an answer to that because it's okay, but you want to be stubborn and you want to say you represent yourself, but you can't even answer that question. Yeah. So if you really see what I'm saying, I'll ask you again. I don't have to keep asking you, but do you want to be represented by counsel, Mr. Styron?
If I was to say yes, is it the public defender's office, or do I get a pro bono one? Like how would that work?
You would get the public defender's office, but you would get one of their attorneys or a group of their attorneys that would be assigned to your case and to represent you throughout it. If they, so that you understand, if they have a conflict, then there are roster attorneys that would then come on and represent you.
So I'm not locked into one attorney. If it gets assigned to me, I'm not stuck with that.
Well, I don't know what you mean by that. But
like I'm not at the mercy of one attorney. If something, like you said, there's some type of conflict, I would be able to address it.
if there was a true conflict that the public defender's office had, then yes, there's a mechanism by which an attorney would be appointed. So you wouldn't just be stuck waving out there.
Okay.
All right. But usually there's not a conflict with the public defender's office. I'm just saying within the public defender's office, you could be assigned any attorney within that office to represent you, or a group of attorneys to represent you. But they'd be able to answer your questions and would certainly make the court feel better that you got somebody sort of guiding you through it.
this case going downtown? This is one of those type of cases that goes downtown?
Well, where it sits right now, oh, yeah. I think you thought you may be sitting in misdemeanor land. You're not.
I don't have a problem talking to it.
Well, you want an attorney to represent you, sir.
I'm willing to stay for a minute. Yes.
Okay, thank you. Quit trying to go around my question. You know what question I'm asking, right? You want an attorney to represent you. This now becomes a public defender case.
Is this a public defender?
All right, this is Mr. Styron. He's got 3 charges. He's got fleeing and eluding, 3rd, resisting, obstructing police officer, and driving while license suspended charge. He now realizes he's not. So you want to adjourn this out
Yes,
a
sir.
week or 2? Mr. Styron, is there anything else holding you right now?
No, I don't, no.
Or you don't know?
No, sir, I don't.
Hold on a second. I'm just trying to figure it out. Hold on.
I'm a family man.
Do you
I got
see-
5 kids at
Do you
home.
see anything else holding him? Because I'll just put it out a week if you can get the discovery and be able to answer everything from.
He reports there's not, Judge, if you could just give me a moment.
All right.
Look at stuff in action.
But he said a lot to me, so I don't know. I'm just messing with you. That's it.
If you believe Miss Apple, this is it.
I only believe Miss Apple. All right, then what I'm going to do is I'm going to put your case out a week so they can catch up with your discovery and everything. Get a chance to talk to you. Okay, Mr. Styron?
Thank you.
Probable cause conference, instead of 2 weeks, 1 week, that'll be May 9th, 2024. 9 a.m. bond will continue. Instead of 2. So they just got to get the information, talk to you, and then you can look at it. Thank you, Mr. Styron. Mr. Styron, that was.
Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh,
I
I've
get
got
a
a substitution right here.
Signed off on.
It is.
All right, then I don't need to address. I don't need
Thank
to
you.
address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there's several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what, at least as I'm to understand, is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct. with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license. Let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license. Ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. All right. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You're covering a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct.
at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was sad, that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines, between October of 2023 and the point in time of the May 15th hearing, was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way, let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my accident.
You were at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements, are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster, performing the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extra judicial statements made outside this courtroom.
Thank you.
Okay, so
Go ahead, counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that. And that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right?
True.
So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
Yes.
I would like to move forward too.
Yes.
On this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it. Because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done, and that's okay. The majority of people that come here on a licensing didn't do what they were supposed to do. That's like a given. They don't go about blaming anybody. They just say, Your Honor, I didn't pay the ticket. Your Honor, I just didn't do it. I just didn't have the time to do it. I just didn't take whatever.
Right.
Just own it. Once you own it, then it becomes a whole lot easier just to move forward. Okay, I'm sorry. I interrupted you and I said I wouldn't, but
Thank you. I understand.
my court.
I
No,
no, I know who you are and I respect that. So and where I am is where I've always been, because I can assure you that when he did speak to WXYZ that day, I wasn't representing him. I was representing him yesterday, right? And you would heard my message is that what steps are to correct this. And that's what I'm about, Your Honor. How do we correct this, right? I understand the entire process. I have not gone into detail, but I will take the word of the court and of Mr. Stiller here, brother counsel, and about the background and the history of it. But how do we go forward? And that's why I'm here to sort of minimize. You okay? Can he did get into an accident.
He can sit down. He can sit down.
Please, Your Honor. Right behind. Oh, well, hold on. Okay. And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here, my client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts, he did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get this driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes, Mr.
I hate to say this, Your Honor, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest. A bench warrant out of
Allen Park.
Allen Park. Mr. Allen.
24th District Court.
Okay.
The shocking thing about it is for a driving while license suspended that he didn't take care of.
Okay. Well, like I said, he
So-
wants to handle.
So
He's
what it
dedicated.
is that, and it's a valid warrant. I happen to be within their radius of pickup. Now, having said that, I don't know if they will pick him up.
Okay.
I will say that what should have happened, I'm not going to go through and try to figure out whether it did happen. But when he was arrested, when he turned himself in on my revocation of bond,
upon being released, he should have been apprised, warned and released to go take care of it. I don't know whether he was. I really don't care whether he was or not. All I know is that was back at mid-May and it hasn't been taken care of. And it's still valid. I was hoping maybe that somebody was going to try and take care of it because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out. So that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you? Come back, because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was Adam. I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not, I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't want that. I don't want that.
You want me?
Yeah.
Okay.
I know you'll never hear me say that. But I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1 o'clock, or would it be at 9 a.m.?
I will set it at 9. We will send an invite now that we have your appearance. So you'll get a direct invite from us as to what time slot he's.
Okay. And then I just need one moment to talk to my client. You want to tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him.
Right.
If they don't come and get him, we'll release him. We're not going to hold him. If they are coming to get him and he's going to be held, the only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay. That will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly,
This has been out there for 9 years.
Well, I did not know about it, Your Honor. Okay.
Counsel, there is not a doubt in my mind that that's true. No, you did not. I go to the bank on that one in a minute, because I know you would have taken care of it.
Yes.
All right.
It's going to be taken care of today. His wife is here and
Okay.
it will be taken care of. So I will absolutely call your office tomorrow to see call the court to see the status of it. Well, we're going to take care of this.
All right.
Okay, that's
Very
what we're
good.
going to do.
We'll see you in August.
Okay.
Defendant is remanded on the Allen Park. Sir, you can go with my bail.
A defense attorney claims a discovery violation, a recorded witness interview that was never disclosed. The judge's response? If you're going to come at somebody, you better bring it. I don't tolerate anything in between.
You versus Corey Falk.
And Lord Yagi, Assistant Public Defender with and on behalf of Corey Folk, who's approaching. Could you say your name for the clerk? Corey Folk.
Sorry. Date and time set for preliminary examination. Are we ready to proceed?
People are ready to proceed.
No, Your Honor. If I may be heard, I know we had a bench conference about this case. Just to put on the record, I indicated that I felt, given the voluminous discovery in this case, I felt unprepared to proceed to exam today, especially given the nature of the charge and the people's representations and just how much discovery there is and how complicated this case is. And as I was sorting through the discovery earlier today, I realized that the witness intent call today was interviewed by police and it was recorded. And that was not disclosed to either side. My position is, Your Honor, that it is a discovery violation under 6.201, recorded statement pertaining to a lay witness, that is mandatory disclosure. And I looked up some case law where there's support for some sort of remedy, which includes either precluding the witness from testifying, or giving the defense an opportunity to review the discovery beforehand. So I would either ask that the court prohibit the witness from testifying because we don't have the recorded interview with police. And I should note also the police actually implicate the witness, I think, based on the notes that are there in terms of what actions the witness may or may not have taken, their motive, their credibility as it relates to the actual allegation, which is of the utmost importance in this type of case, the credibility and the reason why they're testifying, if they're subject to any criminal charges themselves based on their actions or inactions. And my position is either
Making your argument that it's a violation, are you saying that the people knew?
well, Your Honor, they should have known. And if they,
Well, yeah, you're saying they knew.
I don't know whether they knew, but it is mandatory disclosure and it's the officer in charge of the investigation, I think.
Go ahead with your argument.
So, again, there's a recorded statement with a police officer. Neither side has, under People P. Jackson, 292, 583, as well as related case law. And
that there's an interview with this individual, correct?
That's correct, Your Honor. There is not an indication in the report that that review or that interview was ever recorded.
well, if I may, one of the indicators that sort of flagged my attention is why did they go to his house but have him go to their patrol car to do the interview?
Then why didn't any attorney prior to you ask the people for that information? Why at this last minute do you come forth trying to indicate that there's some violation and some penalty that should be attributed to the people? Where were your attorneys before now?
I can't answer that at this time, but what I can say is I did reach out to the people yesterday. I sent 2 emails about this case. I didn't get any response. So even if not for any other reason other than at least And again, yesterday was a holiday, like none of us were required to work. So I'm not faulting Mr. Cook. I'm not faulting the people for that. But I think that it is at this point a due process issue. And it's an issue that if
A due process issue created by whom? If you're going to claim that your client's due process rights are violated and that it happened here, you better bring it, Ms. Yagi. Because the responsibility to also uphold your client's due process rights rests with your office. And you guys have had this case for quite a while now. So I'd be careful about where you want to point fingers on that line. I'll let you continue if you want to continue right now, but you better be careful.
if I may just have a minute, Your Honor.
You can take as much time as you like. In fact, court's going to stand in recess. Court does call the case People versus Corey Folk.
Good afternoon again, Your Honor. Brandon Book for the people.
Public defender with Chaplain before you vote, standing to my right. Do you say your name for the court? Kurt Folk.
All right. Record should reflect we've had a couple of in-chambers conferences regarding this that have gone throughout the day and trying to resolve some issues. I think well, I'll let you say what you're going to say. Go ahead, Mr. Cook.
Thank you, Your Honor. I previously indicated the people were able and ready to proceed today. I would note that as of now, that is no longer true as one of the people's necessary witness. A witness that I believe has been the subject of much discussion for this case has left the courthouse and is no longer responding to attempts to communicate with him or to reach out and find him. We are unaware of his whereabouts at this time. As such, the people are not ready to proceed at this time with that witness. And I believe previously defense counsel referenced a desire to adjourn so that way she could have more time to review the case as well as for the parties to usually go over some found discovery that exists that both parties like to review as it relates to that potential witness's testimony. I did also want to make a brief record related to that additional discovery, as there was a claim that the people, I believe, were the term used was a discovery violation, or that somehow the people were withholding this discovery. I want to make it clear that I did not know this existed until today when Ms. Yagi dutifully was looking through the available discovery and inquired about whether this particular item existed. I asked the officer in charge whether that item does exist, and he indicated that it did, but he did not believe he ever sent it to our office. Nevertheless, I asked him how soon that would be available, and he indicated that it should be able to be copied to a disk and provided to both the people and defense by the end of the week. And I will make sure that that gets done as soon as time allows. I would also just note, again, this is not important to the court's decision today or the people's request, but just making a record. In the report, there's the original report as well as numerous supplemental reports. And of those reports, there's indications of body cam being on some of those reports, but not on the report that would have the interview of this witness. So there was no mark on there. Body camera was on a recording. And so I did not think that there was any until I discovered that it was today. As it stands, I would be joining at this point with defense counsel's request to adjourn the preliminary examination for today. I believe that the date we had discussed was June 15th at 9 in the morning. I have confirmed that that date works with 3 out of the witnesses. 1 witness is unavailable, but I'm confident being able to proceed without that witness. And I was not able to confirm that date with the missing witness for obvious reasons. I believe that's where we stand, and that's the people's request.
One other thing, I'll just indicate that there might be a request for a material witness warrant should the people feel that's necessary given the individual having left and them being under subpoena. Ms. Yagi.
Yes, Your Honor, that is correct. And I will certainly follow up regarding the outstanding discovery.
And let me, just for the court's purposes, say this. I was dealing with this all day from different perspectives and different angles and seeing what we could accomplish today and could we go forth today.
I watch and preside over week after week, where I will watch two of what I believe the state's most efficient offices in terms of what they have to do in our criminal justice system, that being the Washington County Prosecutor's Office and the Public Defender's Office, and that to watch them work tirelessly to try to make sure that all of the evidence, everything is provided. When certainly there could have been a point, not saying that they would, where the people might say, well, we don't have to worry about that piece of evidence. They voluntarily disclose that there's this other thing out there that may not even belong to a police agency, might belong to a third party. Let defense counsel know, and they endeavor to get all of that. Now, I say that because, and I didn't hear everything on it, but I assure you, Mr. Cook, that when the representation was made that there may have been some intentional non-disclosure, I think by my reaction, I think you should have understood. I don't buy. I don't believe that's what happened in this case at all. I don't believe that you knew, as you've indicated. I think that it's one of those things that's there, and quite frankly, in reading the report, is going to be equally as plausible to the defense, who could have then made the request, as it would have been to you. And so that's the way that this court's going to handle it. And as I said, and I'll be frank with you, Ms. Yagi, if you're going to come at somebody, you better bring it, because I don't tolerate anything in between. Preliminary examination in this matter is adjourned June 15, 2026, 9 a.m. before me. Bond will continue. Thank you.
Judge adjourned the preliminary examination to June 15th at 9 a.m. The prosecution admitted they were no longer ready to proceed. Their key witness left the courthouse and isn't responding. The judge rejected the defense's claim of intentional non-disclosure, noting both offices worked tirelessly to disclose evidence. The broader takeaway: discovery disputes are messy, but accusing the prosecution of withholding evidence without proof, that's a dangerous game. The judge made it clear, if you're going to make that claim, you better have the receipts. The case moves forward, just not today. If you found this breakdown eye-opening, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom justice analysis.